Yes, Your Honor, I'm Dennis.
And you are present, and you saying that you do not.
I only received instructions to come on the record last week when this matter came up for me. I've received these statements, perused them, perused the comments. I do not know the matters that the prosecution wishes to prosecute.
I'm sure that he has never been supplied.
Your Honor, I'm aware that my
I believe court can grant them the appointment, given that it was said, but you can take the
I've considered.
We can take a date for ruling on 17th of November.
Give me a date of the hearing.
Yes, it's very good.
So I can deliver my ruling on 17th, then we proceed on 16th of December.
For hearing.
Is that okay?
So it's 17th of which month?
November.
For ruling.
For ruling.
And the second accused has said
Sam.
Your Honor, I request this honorable court ya hearing. Ningeomba kwa sababu Your Honor, nimesikia kumebaki kwa shilingi 8.
Mbaki?
hapana, hakujabaki 9. Wale ni walikuwa leo ndio walikuwa 10, if I'm not wrong. 16 witnesses total.
Remaining?
Total, yes. So after the 8 who were there today, there would have been 8 more. Yes. So kuna 16 wamebaki. 8 walikuwa leo, ingebaki 8 wengine.
Okay. So tukutane tarehe Duncan, tukutane na tarehe 10 kwa mtandao. Nani yule kwa out on bond, si lazima ukuje tarehe 10, sawa sawa? Yes. Ni tarehe 10 tu tutakutana na Duncan kwa mtandao. Hao wengine wakitaka, lakini nani amesema inahusu, you can keep off. Lakini tarehe 16 Disemba zote tukutana. Sawa. Sawa.
Machakos main prison.
Yes, my Your Honor. Yes, Your President.
Duncan Mutinda Mustau. Okay. Number 7. Josephine.
President.
Start first by saying the accused persons in this matter were brought to court in September of 2024. Actually, they took plea on 9th of October 2024. That is when they took plea in this court. You know, that is a year and a few days since that the matter was treated in this court. The first time that any claim has been made by the first accused person that he is unwell is when this application was filed. This application was filed on the 6th of October 2025. Where he's alleging that he suffers from diabetes. And I just wish to point out...
This application is dated?
It's dated 6th October 2025.
You are saying that is the first time issue of sickness?
Yes, the first time ever. With the several mentions we've had, with the several applications we've had, hearings that we've had, that was the first time ever that he said he's unwell. I know for a fact that diabetes just doesn't occur. He just didn't suddenly realize that he has diabetes on the 6th of October. I know for a fact Machakos Prison has a clinic. They have a clinical officer or a doctor who attends to the remandees and the prisoners who are there as a start before they go to Machakos Hospital. We have no record of that whatsoever. The document that council is referring to as a medical report, Yona, it is about 3 sentences. Which just state that the above has been on follow-up due to diabetes mellitus and associated DM neuropathy. Therefore, due to the complicated nature of these conditions, he is advised to adhere to daily medication and lay down dietary requirements in order to detour complications and disease progression. Kindly accord him the necessary support. That's what it says. There's nothing that has been stated about what these dietary restrictions are. Nothing that says this is the medication that you're supposed to take, and prison to confirm that they are unable to meet those dietary recommendations, or they are unable to give him that medication. That is just what it states. I note from their further affidavit that they say, this is, I think it's paragraph 5 of their further affidavit, that by prison endorsing their stamp on the medical report, it supports that prison are unable, this is their wording, that in support of my affidavit dated was endorsed by the prison department by a fixation of their stamp thereon to the effect that the prison department is unable to provide the requisite provisions for my medical condition in all probability. You know, the stamp is just to receive, that they've received that letter. There's nowhere in this document that they filed that prisons have said we are unable to meet any of these things.
Yes, I agree.
The document they annexed as DWK2.
So, tafadhalini tarehe 16 Disemba kwa tarehe kusikizwa. Okay. Lakini mambo ya bond
Ruling
on
on 17th
on bond review
17th of November.
is that no? When is 17?
On a Monday.
Give me the 10th.
The 10th. Yes, it's available. The 10th is available.
Or it's busy.
Not really. Yes, it's a prison mentioned there.
No, I'm talking about, do I have any ruling on that day?
No.
Or judgment?
No.
Okay, so make it a rolling date, 10th of November. Then
Hearing on 16th of December
16th
2025.
December. So hiyo routine mention ya 2 weeks itakuwa hiyo tarehe 10, sawa sawa?
A document, they were given a letter.
Not an endorsement, but
that they are unable to meet the needs. It is just to receive, the way normally you receive, even the way submissions are filed in court and it shows the date it was received. That is all. I don't know the assumption that this means prison are unable to meet any of those requirements. And Joanna, interestingly, when they initially filed the application, they only attached that letter from Machakos, which they are saying is a medical report, which doesn't indicate any medication, doesn't indicate he has been coming to clinic for 3 months, 4 months, 5 months. And upon us replying, and stating that he does not attach any proof that he has been attending clinic. And our reply is dated 21st of October 2025, which we sent via email to council. Council then responded yesterday at 6:41 p.m. in their further affidavit, and suddenly they have appointments, a document showing appointments, and a document showing medication. It is my belief that our response prompted them to obtain these documents. And I will say this because we have stated in our affidavit that since September 2024, the accused has never said that he's unwell, and suddenly the appointment page has a date for 18th September 2024, when he said he went for the first appointment. This is on their further affidavit, indicating that the next appointment was 17th April 2025. If this document...
The next appointment was?
17th April 2025. If this document is to be believed, the accused would have made this application that he is unwell when he was making the application for bond, which application was made on 18th December 2024. We had it 14th January 2025, with the ruling being delivered 20th January 2025. By then, he'd already, if we were to believe this document, he'd had already gone for the first appointment.
So you're saying that if indeed he was unwell, and the case should have made this known to the court
On
at the time of the ruling of?
Even by the time he was making the application for his application for bond, which was bond was suspended on 18th December 2024. And we had the matter, I believe it was 14th January 2025. By then, he'd already allegedly gone for the first appointment and received his second date for the appointment, which is 17th April 2025. By this time, he'd already, by that 17th April 2025, he'd already even made the application before the High Court for review of this court's ruling of 20th January 2025. That issue was not even raised in the High Court. And just to continue, he had a third appointment of 17th September 2025, according to this document, if we were to believe it.
Once, which repeat the date again?
17th September 2025. You know, we were here 26th August 2025. On that date, he already knew he had the appointment of 17th September. If
That
we had
was on which
this
day?
document, 26th August.
And 26th August.
2025. We had a hearing date here. 5 witnesses testified on that date.
They're saying by that
Sorry,
time-
5 witnesses, testified on that date. By that time, he already knew his next appointment was 17th September 2025. No mention whatsoever to this court. Throughout this process, the first accused has had an advocate of his own choosing, not a pro bono advocate, an advocate of his own choosing. He has had time to communicate with that advocate. I even remember there was a hearing that we even took a break for him to contact and speak to his advocate during the hearing, because he said he wanted to inform that the advocate something. No mention, never mentioned that he was unwell until this application of 6th October 2025. Unless he's saying from the documents that they've attached, he's been going on for clinic, but on 6th of October is when they discovered he has that diabetes. I believe these documents are not believable. It is also my opinion that, and the IO in the initial objection of bond informed this court how they found out that the complainant was being intimidated and threatened. And even when we did the first hearing of this matter, I know counsel was not there, the second accused himself indicated to this court that the first accused told him what to say. And that is how he was contacting the complainant. Your Honor, this was also proven through investigation by cybercrime. The SIM card that was used, the phone number, the phone that the SIM card was placed in, and how it was traced back to the second accused person. And even the complainant, during his own testimony, informed this court that every time he would go to the police station is when he would receive these calls. And he was going to the police station with the first accused person. And immediately they leave the police station, he would get the calls, the threatening calls and the intimidating calls. And we are apprehensive that if the accused person is released, he will abscond, Your Honor. It matters not that he's put a copy of his title deed. There's nothing we can do with the title deed if he's absent and if he's absconded. You know, this was the same finding that the High Court made, that already the evidence that had been adduced by the IO in opposing this bond and in opposing the application in the High Court is weighty. And that is why they stated that the ruling of the court of 20th January 2025 was appropriate. Nothing has changed, Your Honor. The accused has an option of
indeed needs continuous monitoring, specialized care, and dietary management, together with timely medication, Your Honor. Your Honor, it is our humble submission that these requirements which have been Your Honor, we further anchor our submission upon Article 29F of the Constitution of Kenya.
Article 29F.
29F of the Constitution of Kenya, which provides that every human being has the right to freedom from cruel, inhuman, or degrading treatment. Your Honor, it is also our further submission that previously when this matter was determined by the court, it was determined that there were some allegations of intimidation of the witnesses, Your Honor. On this submission, Your Honor, my client, the first accused person, saw in his affidavit that he saw that the evidence before the court, which came out during the hearing, the previous hearing of this matter, was that upon investigation by the by the PCI, it came out that the number that was allegedly used to confer the threats or intimidation did not actually belong to my accused, to my client, Your Honor. And this actually came out well before the court, and the same has been sworn in the supporting affidavit of this application by my client. Your Honor, further to the foregoing, previously the court noted that the prosecution put forth that the complainant and further important witnesses had yet to testify, but as at now, Your Honor, the complainant has indeed testified, and also the crucial witnesses which the prosecution said that they have to testify have already indeed testified, Your Honor. Your Honor, in light of my submission, it is upon the prosecution to enable, if they feel that the witnesses shall be intimidated in any manner, we have witness protection mechanisms, Your Honor, within the law, and they are free to adopt the same to ensure that there shall be no intimidation of the remaining witnesses, Your Honor. Your Honor, in finalizing a submission, I pray that this honorable court be pleased to review the bail and bond terms, Your Honor, owing to the grounds raised, more especially the health of my client, Your Honor, which in all probability cannot receive treatment when he is in custody. Your Honor, we give a proposal of bail and bond terms of Kenya shillings 500,000, which shall be fair and just in the circumstances.